I had the coolest job that any electrical engineer could ever have on the ground crew for Solar Impulse 2, the first solar-powered airplane to fly around the world only using the power of the sun. IEEE-USA has given me a competitive edge because of their support system. It is so much easier doing something and being out of your comfort zone when you have someone there saying, "You got this." IEEE-USA is more than just a network, it's a family.
Good afternoon, everyone, and thanks for tuning in to today's IEEE-USA Livestream webinar, Trademark Basics. I'm your host, Jonathan Cho. This is the fourth webinar hosted by IEEE-USA in partnership with the United States Patent and Trademark Office on intellectual property. For information on our previous ones, you can check them out on our link that we provided in the screen below, as well as in the comment section. IEEE-USA's goal is to create programming that is valuable, relevant, and of interest to you. As such, we will be sending a short survey to all registrants after this event and would love your feedback. We value your opinions and would appreciate it if you could take a few minutes and share your thoughts. Joining us today is Jason Lott from the United States Patent and Trademark Office. Jason is the attorney advisor for Trademark's customer outreach, where he specializes in helping small business owners understand trademarks and the federal trademark registration process through live presentations, creative videos, and other multimedia platforms. He's been with the USPTO since 2000, previously serving as the examining attorney, and is a recipient of multiple career awards. Without further ado, I will now pass it off to our presenter. Welcome, Jason. Glad you could join us today.
Thank you very much. Very happy to be here. I'm going to go ahead and share my screen and we'll jump in and get started. All right, well, there we go. So, hey there, everybody. As Jonathan said, my name is Jason Lott. I'm the attorney advisor for Trademark's customer outreach at the USPTO. And what that really means is it is my job to teach you about trademarks, what they are, why they're important, and how the federal registration of your trademark can help you build your business. This is kind of what today is going to look like. We're going to move pretty quickly, but I do want to make sure that I can get to your questions. But we want to cover sort of the basics of trademarks, what they are in general, why you might want to register your trademark with us, how you go about selecting or choosing or creating a strong trademark. We're going to very briefly touch on filing and registration. And then I want to show you a couple of resources that you might want to look into after today to learn even more about trademarks. So let's dive right in and talk about what a trademark actually is. Well, as you can see on your screen, these are all trademarks. They're probably all trademarks that you recognize from everyday life. There are two things that I really want to point out here. One of them is, hey, these appear to be in black and white. And you've probably never seen these trademarks in black and white. So why in the world are they in black and white? Well, we'll talk about that in just a second. So I just want to hang a little lantern right there and we'll come back to it in a few minutes. But the main reason that I want you to take a look at this slide and take a look at these graphics is because they do a great job of helping us understand what trademarks are. So if I was to look in the top left-hand corner there at the Apple logo, what do you think of? Computers, right? Or maybe smartphones or earbuds or, TVs or, services or watches or whatever. But if I say Coca-Cola, what do you think of? Soft drinks. McDonald's, hamburgers. Amazon, buying stuff online. Samsung, consumer electronics. Microsoft, hardware and software. Google, search engine. Nike, shoes. Ford, trucks, right? So every single time you see or hear or experience a trademark, it automatically makes you think of very particular goods and services. And that is incredibly important because a lot of times people don't understand the relationship between a trademark and its underlying good and service. And we're going to talk more and more about goods and services as we get deeper into today. Well, this is what a trademark is. It is identifying the source of goods and services. In addition to that, it is distinguishing them from the goods and services of another party. So probably the easiest example to think of is one that probably happens to you all the time. You sit down in a restaurant, the waiter comes over, says, "Would you like something to drink?" And you say, "I would love a Coke." And he says, "Is a Pepsi okay?" Right? That is a trademark in action. You are using the Coca-Cola trademark to identify the source of the goods that you want. The waiter is using the Pepsi-Cola trademark to identify the source of the goods that they provide. And you are both using those trademarks to distinguish those goods from each other. So if you're a small business, or let's say you invented something, and you want to have a brand name for the new thing that you've invented, well, you should be thinking about what is the thing that you use to help identify the source of your goods in the marketplace, or to identify the source of your services in the marketplace. How do you distinguish them from your competitors? What we're talking about there is a brand, and specifically a trademark, which provides legal protection for your brand, right? Because you got to be able to protect it. It's one thing to have it, but you want to be able to protect it. So this is what a trademark is and what a trademark does. Let's very briefly talk about what a trademark does not do. Okay, so a trademark does not mean that you legally own a word or phrase. It does not mean that you can stop other people from using that word or that phrase. And it does not mean that people owe you money if they use a word or a phrase. I've heard that one before. Oh, if somebody uses my trademark, that means that they owe me a nickel, right? No, not exactly. So what we're trying to get at here is the fact that a trademark does not give you legal ownership of a thing, of a particular word or phrase. Think about a common everyday word like apple. Apple has a registered trademark for Apple, but does that mean that they own the word apple? Does that mean they can stop me from saying the word apple or from eating an apple that I pull out of my fridge? No, of course not. But what it means is if I invented a smartphone and I wanted to brand it as an Apple smartphone, would I be able to do that? No, because Apple has the exclusive right to use the Apple trademark as a brand name for smartphones. It's kind of a subtle distinction, but it's very important that we understand that difference, because you hear it all the time. People say, "I want a trademark so I can stop other people from using that," and that means they have to pay if they do. Well, I guess if you were to license something as a trademark, perhaps they would have to pay you. That could be a relationship that could be in place. But just because somebody says a word or says a phrase does not mean that they are the legal owner of it or that they would necessarily owe you money. Okay, so trademark is the exclusive right to use something as a brand name, slogan, or logo to indicate the source of goods and services. And those are really the big three when we think about what a trademark actually is as a common source identifier: brand names, slogans, and logos. Right? That's what we really think about when we think about what trademarks are. And you can see on the bottom of the screen there, those are some examples of some pretty well-known trademarks from the Coca-Cola company. In the bottom left-hand side there, that's an example of a brand name that has been registered with our office. Now, you might notice that it's in Times New Roman for some reason. Have you ever seen Coca-Cola written in Times New Roman? Yeah, probably not. But that's the way they registered it with us, because that has very special significance. And it's the same sort of significance that you can have if you apply to register your brand name with us in what is known as a standard character format drawing. And what that means is you have exclusive right to use that word as your brand name, or wording as your brand name, and you are not locked into it appearing in a very particular way. So that means over the life of the trademark, you can use your wording in whatever font, style, size, or color you want to, and you're not locked into it appearing in a very particular font, or a particular color, or a particular style. So it might sound limiting, but it's actually incredibly expansive because you're getting a registration for the wording itself. And Coca-Cola clearly has done that here. Folks will often ask, "Hey, can I register a tagline? What about a slogan? Can I register that?" Yes, absolutely you can. It's just a combination of wording, right? Well, there might be some additional wrinkles that come into play there when you're talking about registering a slogan, but sometimes people are able to iron them out. And so, yes, you can register a slogan or a tagline as a trademark. You see there in the center, "It's the real thing." That's a slogan of Coca-Cola's, and they have registered with us, once again, in standard character format. which means they can use it in whatever font style, size, or color they want to over the life of the trademark. You too have that option as a trademark owner to register that version of your trademark with us. It's important to understand that you are able to register different versions of your trademarks. So you can see on the right-hand side there, various logos of Coca-Cola. The one there, Always Coca-Cola, there's sort of like button logo there that's a combination of a wording and a design. And also on the right-hand side there, the two-dimensional shape of a Coca-Cola bottle. That sort of shape design registered there as a trademark. So if the stylization or the design of your trademark is important to you, yes, you have that option to apply to register that version of your trademark with us. It is up to you how many different versions you want to apply to register with us. It just depends on your bank account and what all you can have. You can give evidence of the fact that you're using in interstate commerce. So getting back to why these trademarks appear in black and white, you'll notice those down in the bottom right-hand corner are in black and white. You'll probably never see Always Coca-Cola in black and white. The reason that those are in black and white is that Coca-Cola has decided to take the option to register the trademarks in black and white. That does not mean that they have to use them in black and white, because black and white has special significance for us here. And that means that you're saying, hey, USPTO, I am not claiming any colors in my trademark that I'm applying to register with you. And that means over the life of the trademark, you can use it in whatever colors you'll want to, right? That's not the case if you apply to register your trademark in specific color. In that case, you are locking yourself into what the trademark looks like. And so if Always Coca-Cola was in red and green and brown and white and gray, well, technically, their protection would be limited to their trademark appearing in those colors. So I'm not allowed to give legal advice. So what I'm saying is not legal advice, but I can tell you over all of my years working as an examining attorney and now working with small business owners, that most of the time what small business owners do, if they don't have a whole lot of money to put towards trademark registration, is they do one of two things. If the wording is important to them, they apply to register their brand name or their slogan in standard character format, because it gives them this broad flexibility over the life of the trademark. Or if the stylization or design or of the logo is important to them, they might apply to register that version, but they do it in black and white to give themselves flexibility over the life of the trademark to change up the colors that they use in it. So again, not legal advice, but those are things that I have seen people do over the years. It might be something that works for you. The other thing that I want to point out, aside from brand name slogans and logos, is that just about anything can be a trademark so long as it indicates source. So you can see some examples up there on the screen. Now the sort of brick that's down there in the bottom left-hand corner, back in the day when I first started, at that time, you were not allowed to submit a color drawing, and you had to submit your drawing lined for various colors. You probably can't guess it just based upon that brick, but that brick there is lined for the color pink. And so what that actually is a sort of brick of fiberglass insulation. And so what has happened here is that Owens Corning has registered the color pink for fiberglass insulation, because anytime you see pink fiberglass, you automatically think of them, but you think of Owens Corning. So it is possible to register a color as a trademark when it is used with very specific goods and services. I've never really bought anything at Tiffany's, so I don't have any real life experience with this, but we've all seen a Tiffany blue box that has jewelry inside it, right? That blue color, that sort of robin's egg blue color in the box, that is registered as a trademark. Probably the most common example that we see every day driving down our streets and parking on our streets that's the color brown, because UPS has registered the color brown when used with panel trucks and with uniforms for their parcel delivery services, right? Because every time you see that brown truck, you immediately think, oh, yeah, that's UPS. So I want you to think expansively here and realize, yes, color can be registered as a trademark so long as it indicates source. The sort of skateboard, surfboard looking thing down there in the middle, that's actually a hologram. Upper Deck has registered a hologram or two, actually, I think, for their sports trading cards to indicate the source of those. And you probably recognize the example in the bottom right-hand corner. That is the three-dimensional configuration of a Coca-Cola bottle. And that's because if you walk into a convenience store, you look in the refrigerated case and you see a bottle that is shaped like that, filled with brown liquid, Coca-Cola, you know it automatically. And that is a great example of how a trademark works. If you see it or experience it in some way and it indicates the source of goods and services, it is functioning as a trademark. And that is something that can potentially be registered with our office. Now, you are not required to have all of these things or any of these things, all right? I just want you to think creatively about what you might be using as a business owner to indicate the source of your goods and services. Maybe it's not just a brand name or a slogan or a logo. Maybe it's something like this, a certain color combination that you're always using. Think about John Deere green compared with, and yellow. You often see that on some of their agricultural implements and things like that. So it can be a combination of colors as well. So I want you to think broadly, all right? Now we're going to do a little knowledge check here. You don't necessarily have to reply to everybody and post anything in the chat or in a Q&A. Just you can keep the answers to yourself. It's okay. I know you're going to get it right. The question, does a federally registered trademark mean that you own a word or phrase? No, we've already talked about this. It just means that you only have the exclusive right to use that word or phrase to indicate the source of your specific goods and services. And what about this one? Do you have to use your business name as your trademark? Think about that one for a second. And the answer is no, you do not have to use your business name as your trademark. You can if you want to, but you're not required to. And I get that question a lot. Folks will say, Jason, I have my business name. That's my trademark, right? No, not necessarily. A business name just gives you the ability to do business in your particular state. It is not necessarily a trademark. It could be, but it doesn't have to be. So think about Google, for example. I think their business name is like Alphabet Inc. or something like that, but their trademarks are things like Google, Gmail, YouTube, right? So you could have the same situation for your business where you have a really kind of, boring or generic sort of name for your business name, but have something super awesome that you use as your trademark. All right, so now that we know what a trademark is, let's talk about why you might want to register it with us, with the federal government. So there are multiple ways that trademark rights can be created in the United States, but we're going to focus on two of the main ones, common law and federal registration. And I'm going to walk you through both of these things. So common law trademark rights are the quickest and the easiest. They are created as soon as you begin to use something as a trademark. There you go. Okay. Now, these rights are usually created under state law, whether it's case law or a statute or something like that. The problem with them, though, is that they are limited to the geographic area in which you are operating. And again, these are going to be intra-state. Okay, so just inside state lines. And it could be even more restrictive than that. So let's say that you have a business where you're selling apples, from your orchard, and the only place you're selling them is at the farmer's market in your town. And you're not on the internet, you're not posting on social media, you just, getting your apples and you're carting them to town and you're selling them at the farmer's market. Well, your trademark that you're using for these apples is only going to be limited to that geographic area in which you're operating. It's not going to be, you're not going to have rights outside of that area because nobody knows about it. So it's not really indicating source for anybody else. It's only in this specific area. And that's fine if you want to. I mean, you could always have a very small business. You're just going to keep it small. That's fine. But a lot of folks want to expand their business. They want to grow their business and pass it down to their kids and to their grandkids and their great-grandkids. So it's a limitation with common law trademark rights. They are harder to defend and enforce at times, but they are an option and you can always rely on your common law trademark rights. Now, the way that you can let people know that you're claiming a common law trademark right is you put a little TM after it, or you put a little SM. TM stands for trademark, SM stands for service mark. You can use those at any time. You don't have to ask permission from anywhere. There's no font that you have to use, no size that you have to have it, no place around the trademark where you have to put it. I've seen it, at the front, at the end, at the bottom, in the middle. You can kind of put it wherever you want to. It's really up to you. And that TM and that SM are letting the public know, hey, I am using this as my trademark to indicate the source of my particular goods and services. The one thing to be aware of, however, is that you are not allowed to use the R in the circle symbol. That is limited to federally registered trademarks. So until such time as you register with us, you are not allowed to use the R in the circle. But of course, you're free to use the TM or the SM. And so all of this is fine. If you just want to operate your small business and cart your apples to town and sell them to the townsfolk, sure, you can do that. But if you want to expand your business and you want to have it grow, you might want to think about registering your trademark with us. Because when you register your trademark with the federal government, you are getting federal rights. What is happening is it is creating a legal presumption that you are the owner of the trademark, and that you have the right to use it throughout the United States and its territories. And so no longer just this tiny little jurisdiction, but you have the presumption that you can own it and can use it throughout the entire United States. And again, that's a pretty big deal, right? And this is also, remember, creating a presumption, something you can say, hey, judge, all right, I have my registration right here. And the judge says, yeah, well, we're going to presume you're the owner and have the right to use it. That's not true with common law rights. At that point, you'd have to be like, well, judge, let me explain to you. Okay, so I first started off in 1982, and so you're gonna have to explain. No, with a federal registration, it creates this legal presumption that you are the owner and have the right to use it. You're putting the public on constructive notice of your rights in the trademark, and that means that your trademark is going to be listed in our database, which is fully accessible to anyone in the world 24 hours a day, 7 days a week. You can bring legal action concerning your trademark in federal court. And this is a really great benefit if somebody on the other side of the country starts infringing on your trademark rights. So rather than having to go all the way across the country to sue some guy to get him to stop infringing on your trademark, instead, you can file in the federal courthouse nearest you regarding your trademark and make that guy infringing come to wherever you are in order to defend against his actions. You can also record your registration with U.S. Customs and Border Protection. And especially in the technology field, this could be a really huge benefit. If you think about the counterfeit goods that are coming into the country, think, software and electronics, not to mention footwear and apparel and, personal protective equipment and all that other stuff, right? So what can happen here is that you record your registration with CBP, and the CBP agents will work to try and stop those counterfeit goods from entering the country at our ports and our borders. So that's a really great benefit that you would then have access to with a federal registration. You can also use it as a basis for filing in a foreign country. Some of you might be aware that intellectual property rights are always country-based. So if you want trademark rights in the US, you got to protect in the US. If you want rights in Canada, you got to protect in Canada. Same with Mexico and any other country throughout the world that has an IP system. So that means if you want to expand your business into Canada or from Canada into the United States, you're going to have an application and registration in that country. So if you're expanding your business and you want protection for your trademark in Canada, you're going to have to file there. Now, typically you would have to, set up probably hire a local attorney and file that way. But what's great about having a federal application or registration with us is that it gives you access to what's known as the Madrid Protocol, which allows you to more easily work to extend protection into various countries. Now, you're still going to have to file applications. You're still going to have to pay fees. It's still going to take time. But the whole point of it is to streamline the process a little bit. So you can say, yes, I want to file in this country, and I want to file in this country, and this one over here. And then you pay your fees and file your applications that way. You're still going to have national applications in those countries that you choose, but this process is intended to make it easier and more efficient for you. Also, once you register with us, you no longer need to use that TM or the SM. In fact, you should, get rid of it altogether and replace it with the R in the circle. So because you're registered, you can now use the registration symbol, which is really kind of the gold standard when it comes to trademarks. All right, so quick knowledge check before we move on. Are you required to register your trademark with the USPTO? Answer is no, you are not required. There is no law, no regulation that says you must register your trademark with us. You could go your entire business life and only rely upon your common law trademark rights. And does registering your trademark with the USPTO give you international protection? We just talked about this, and the answer is no, it does not. Registering your trademark with the USPTO only gives you rights inside the United States. If you want protection in other countries, you need to make sure you have an application and registration in those countries. Okay, so now we know what a trademark is. We know why you might want to register your trademark with us. Let's spend some time talking about how to select or choose or create a strong trademark. So there are a couple things to keep in mind. The mission of our office is to register trademarks. Okay, we want to register trademarks. We would love to be able to register every single trademark that comes through the door. However, we can't, because there are laws and regulations that are put in place and that we have to apply to every application. There is an examination process that takes place when you apply. You apply, an examining attorney is assigned to your case. The examining attorney examines, right, the application to determine whether your trademark is registrable. And as you can see on your screen, not every trademark is registrable. There are reasons why a trademark might be refused registration. We're going to talk about two of those in just a minute. The other thing to keep in mind is that even if your trademark does register, that registration might not be enforceable. Now, I know if you're thinking about it, you're like, how is that possible, Jason? I just spent all this time and all this effort in order to get my trademark registered. Are you telling me I cannot enforce my registration? And the answer is maybe. And the reason for that is common law trademark rights. Because remember, there is no law that says you have to register with us. So it's possible that you could go your entire business life and never register, but still have greater and stronger rights than someone who has registered. Let me just give you a really quick, exaggerated example. Let's say that Levi's never got around to registering the Levi's trademark for blue jeans. All right, they decided to always rely on their common law rights ever since 1873. And you think, oh, you know what? I've just, I've sewn this new pair of blue jeans that I'm going to be selling. I want to call it Levi's. Let me check and see whether Levi's is registered. Oh, Levi's is not registered. And so you go through the process. You register Levi's as a brand name for your blue jeans. And are you going to be able to enforce that registration? No, of course not. Because Levi's, who's been around for what, almost 150 years or something like that, is going to say, whoa, 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 whoa. We have stronger common law trademark rights. We are going to essentially file for a cancellation proceeding in order to cancel your registration. So you would have gone through all of that time, all of that effort in order to get registration, and then not be able to use your registration. Well, clearly nobody wants that to happen. We don't want that to happen. You don't want that to happen. So it's very important that you're selecting a trademark that is both federally registrable and legally protectable. And the two things that I'm going to talk about right now are going to hopefully go a long way towards helping you make sure that your trademark that you are going to be using with your business is both of those things. So the first thing we're going to talk about is likelihood of confusion. And it appears in this registration context as a likelihood of confusion refusal issued by the examining attorney. The other issue is the strength of your trademark, and that makes its appearance in what is known as a descriptiveness refusal issued by the examining attorney. Now, keep in mind, just because you see these refusals listed here, it does not mean that they're going to happen, all right? They could happen depending on your trademark, but these are not guarantees that you will get a registration. When I was an examining attorney, I loved it when somebody would submit an application and there were no problems with it, no refusals, no requirements. I could, essentially stamp that thing approved and get it moving on to the process. But obviously there are situations where that's not the case, and I would have to issue these types of refusals. And these are two of the most common types of refusals that happen at the office. So let's go through them one by one. Okay, first let's take a look at this likelihood of confusion issue. So the concept here is that we need, as a society, to avoid situations where consumers are confused about the source of goods and services. Sometimes you hear about it as trademark infringement, that someone is infringing on somebody else's trademark rights. Well, it's the same sort of concept in that a consumer is confused when they encounter two things in the marketplace. Like, oh, I'm assuming, I guess one company is doing these, I'm not sure, but in reality, it's two different companies. But as a consumer, you get confused. And the test that the examining attorney is going to apply in this case is going to ask essentially a two-pronged question. Now, it's obviously more complex than that, but it boils down to these two things. Are the trademarks, when you compare them, confusingly similar? And in addition, are the goods and services, right, that are used with these trademarks related? Now, notice I did not say identical. So the trademarks don't have to be identical and the goods and services don't have to be identical. They just have to be similar and related. And with similarity, we're asking the question, do the trademarks look alike? Do they sound alike? Do they have a similar meaning or a similar commercial impression? Doesn't have to be all those, could just be one of those. And in addition, does one company typically make both types of goods? Or does one company typically provide both types of services? Or does one company typically provide this type of good and this type of service? Right? If so, those goods and or services would be considered to be related. And if you have yeses to both of those prongs, that's a likelihood of confusion, and the examining attorney would need to refuse registration. Okay, so the examining attorney is going to issue the refusal if the trademark in the application coming into the office is confusingly similar to one that she finds in our database. So the trademarks are similar, and in addition, the goods and services in your application and in the registration are considered to be related. Now, some of you might be wondering about relatedness. It's kind of a fuzzy concept. There isn't a bright line rule. There's no mathematical formula that you can use to determine whether or not something is related. It's all evidence-based. And the examining attorney is going to be doing research to determine, are these related? Are they not? What would a reasonable consumer think? Would a reasonable consumer or purchaser be confused and think that one company is providing both of these things? If so, they would be considered to be related. All right, so that's the basic concepts. I'm going to show you a couple of examples to hopefully drive it home. So let's say that you wanted to register T-Markey as a brand name for shirts. The examining attorney looks in our database and she finds T-Markey for pants. Is there a likelihood of confusion here? Yes. The trademarks are, well, in this case, they're identical, but they're similar. And in addition, shirts are related to pants. Right? One company is typically making both shirts and pants and socks and shoes and sweatshirts and all the other stuff, right? So in this case, yes, a likelihood of confusion. Let's change it up a little. What about T-Markey for shirts and the examining attorney finds T-Markey for pants? Let's do the analysis. Is T-Markey similar to T-Markey? Yes. They might not look alike, but they sound alike. In addition, as we know, shirts are related to pants. So again, there'd be a refusal in this case. What about this case? You want to register T-Markey for shirts, and already registered is T-Markey for golf flags. We'd have to do the analysis. T-Markey similar to T-Markey? Yes. Are shirts related to golf flags? I don't know. I would have to do some research to discover whether companies typically make both golf flags and shirts. It may be that they do, but it may be that they don't. And if they do, if there's evidence that companies are making both of these things, then there would probably be a likelihood of confusion in this case. But if there's no evidence that a consumer would think that, the maker of one is also the maker of the other, well, these two things could potentially coexist and there would be no refusal. It's important that you understand this likelihood of confusion analysis, because the great thing is you can do this thing called a clearance search before you apply. because that's what you're doing is you're clearing the area around your trademark to make sure that there's nobody else out there using a same or similar trademark for related goods and services. What we suggest before you file is you look in our database. You use the trademark electronic search system called TESS, and you can look to see. You're looking in the exact same database as the trademark examining attorney. And you can execute searches in there as much as you want. It's all totally free. I'll tell you right now, the interface is pretty dated. It's 20 years old. We're working on a new version of it, but it's not ready yet. So until that time, you're stuck with the one that we have. But you can look in there, you can look to see, is there anybody else that's in our database using a same or similar trademark for related goods and services? You can do that on before you file. And I can tell you, having examined before, there'd be situations where somebody clearly had not done that search. They applied to register a trademark, and there is something that is a dead-on hit right in our database, almost like the exact same mark being used for incredibly similar and related goods and services. This person is now out time and effort and money, and they could have avoided it by doing that search before filing. Now, we also recommend that part of your clearance search is looking online. Common law trademark rights are not something that we are concerned with as a federal agency. We are only concerned with federal registration. We don't look at common law rights or state trademark rights or foreign trademark rights or anything along those lines. We are only looking in our database to see whether or not you can register. But it's important that you do that search on your own, because remember that Levi's situation, right? You want to see, is anybody else out there using a same or similar trademark for related goods and services? So pop your trademark into Google or Bing or Yahoo or DuckDuckGo or whatever engine it is that you like to use, and see what you come up with. So that's the very basics of what we would recommend for a clearance search. If you want to go all out, we would recommend hiring a private trademark attorney. And the attorney is going to be able to do this full-on comprehensive clearance search for you. Look in our database, look for common law stuff, look in state trademark databases, foreign databases, business names, all that sort of stuff. All sorts of sources that I cannot even comprehend. All right. So if you want that full analysis, you might want to think about hiring an attorney to help you. Now, I know that trademark attorneys can be expensive, so I think we'll have a little bit of time. I can talk to you about a couple of resources that are free and reduced price legal services. So before we move on, though, let's do a real quick knowledge check. Who says there's a likelihood of confusion here? X seed for agricultural seeds, and the examining attorney finds X seed for live plants, right? Similar trademarks. They might not look alike, but they sound similar. And so the question becomes, are agricultural seeds related to live plants? Yeah, probably. Now, I haven't done the research, but my guess is companies that do seeds also do live plants. You know, it depends on how much time you spend, you know, hanging out at, I guess, at the local garden center of your local hardware store, or maybe you work in agriculture, so you know the answer to this already. So that would be the research that would have to be done to determine, are agricultural seeds related to live plants? All right, so that's likelihood of confusion. The other thing I want to cover is the strength of the trademark. And so what we're talking about here is avoiding trademarks that fail to function as trademarks to indicate the source of goods and services. This is what is known as a descriptiveness refusal, which would then be issued by the examining attorney. And so the question is, does the trademark describe the underlying good or service? And if so, it's not functioning as a trademark. It's just telling you something about the goods. It's not indicating source, it's describing. So think about an example of a trademark. The trademark is apple pie as a brand name for potpourri. Well, you probably can guess that the potpourri smells like apple pie. So it's not really functioning as a brand for potpourri. It's kind of telling you what the scent of the potpourri happens to be. Now, there's something in trademarks called the descriptiveness spectrum. I like to think about it as a temperature gauge that goes from weak to strong or cold to hot. And you want your trademarks to be on the hot end here. Fanciful trademarks, arbitrary trademarks, suggestive trademarks. You want to avoid the weak ones. So let's talk about what those are and knock those out right away. So generic terms aren't even trademarks at all. It's just a common everyday name for the thing, for the good or service associated with your trademark. These are unregistrable. You cannot register a generic name of a thing as a trademark. So the example would be milk. for a dairy-based beverage. You would never be able to register that because it's not functioning as a trademark. Now, slightly better than that, but still not great, are descriptive trademarks. They describe something about the goods and services, right? Think apple pie as a brand name for potpourri. These are also unregistrable at our office on the principal register. Now, I haven't talked about the two different registers, principal and supplemental. And the reason for that is because you want to be on the principal register. That's where you get all of those sweet, sweet nationwide federal benefits, okay? You get less of those on the supplemental. Supplemental is really for trademarks that could function as trademarks, but they're not really there yet. Okay, you don't necessarily want to be on the supplemental, you want to be on the principal register. Well, descriptive trademarks are refused registration on the principal unless there is a showing of acquired distinctiveness, which means the trademark is now functioning to indicate the source of specific goods and services. The example here would be creamy whip for whip topping. So technically this is going to get a refusal. It's whip and it's creamy. So you know that the underlying goods are creamy whipped topping, right? So it's not really functioning as a trademark. But in this case, it was registrable with a claim of acquired distinctiveness. So it's possible to register these trademarks, but the scope of your protection is going to be pretty small. That's why we always recommend you want to think about those trademarks on the hot end of that temperature gauge. Think about suggestive trademarks that suggest a quality of the good or service, but it doesn't exactly describe it. These are registrable. They are inherently distinctive. An example of this would be copper tone for suntan lotion. So it doesn't tell you it's suntan lotion. It suggests that if you use the suntan lotion on your skin and you go outside in the sun, your skin will take on a coppery tone, right? So your mind is making these leaps and jumps in order to like, oh yeah, okay, yeah, I guess I see. Okay, it's kind of suggests what the goods are. Suggestive trademarks are great. Those are registrable. Also great are fanciful trademarks. Now, these are invented words that have no meaning in English or in any other language. They're sometimes called coined trademarks. These are also registrable. They are inherently distinctive. An example would be Xerox for photocopiers. Now, you and I might hear Xerox and we immediately think photocopiers, right? Sometimes people use it incorrectly as a generic term, okay? But it's still a registered trademark, and it indicates the source of photocopiers. Now, when they first came out, who knows what Xerox means? But now we have learned as consumers, when we hear Xerox, we think photocopiers. That is a pretty broad scope of protection, right? Same thing with arbitrary trademarks. These are words that have meaning in English or another language, but no association with the underlying good or service. These are also registrable, also inherently distinctive. An example would be Apple for computers. Apple is a common everyday word, but the word Apple has no association whatsoever with computers or mobile phones or earbuds or watches and all those other things. Again, you and I as consumers, when we see it, we think computers or phones, but the wording itself on its own is arbitrary when applied to the underlying good or service. So real quick knowledge check, because I know we're getting close to time. Which of these would be registrable? Bicycle as a brand name for bicycles, or bicycle as a brand name for playing cards, right? We can quickly and easily do the analysis. Bicycle for bicycles, nope, that is generic. It is not going to be registrable as a trademark, but bicycle is arbitrary when used as a brand name for playing cards. And the bicycle playing cards, trademark has been around for probably over 100 years at this point. So arbitrary usage of a common everyday word, fine. But just if it's used generically, it's not going to be registrable. All right, I'm going to quickly move through this section. And the reason is not because it's so easy, but because it's pretty complex. And we just don't have time to go through all of it. All right. So this is just a quick breakdown on what the filing process or the registration process looks like should you decide to apply to register with us. You apply. We examine. There's this weird sort of publication phase in which there's a 30-day opposition period in which anybody can oppose their mark if they have reason to. And if you make it through that, you move on to registration. That's the sort of basics of it. You apply, we examine, publication, registration. So the overall concept is pretty easy, but it can get pretty complex when you boil down to specifics. If you do decide to apply, you would use the Trademark Electronic Application System called TEAS, T-E-A-S. As you can see, there are 2 flavors of TEAS. I'll talk about that in just a second. In your application, it's going to be, there are several things you have to include. A drawing of the trademark called a representation. So think about that standard character format, the special form format, the black and white version versus the color version, those things, that's considered your drawing, because you have to tell us which version of your trademark you want to apply to register. In addition, you have to list out the goods and services that you're using with your trademark. We have to know what those things are. You also have to include a filing basis for every good or service that you list, which says, yes, I'm already using it across state lines. No, I'm not using it yet, but I have a bona fide intent to, things like that. We also have your contact information, and of course, there's a filing fee. The filing fee, the standard fee is $350 per international class. I'll talk about that international class in just a second. But as you can see there, if you file using TEAS Plus, you get a discount. You get $100 off per international class. And the reason for that is we want you to use our TEAS Plus version of the form. It's more efficient all around, and we're hoping to incentivize you to use it. So what that really means is you're front loading your application with everything that's going to need to be in there. So unlike under a standard situation where the examining attorney might have to be like, hey, I need you to turn in the such and such and the thing over here. Not with TEAS Plus, you're going to put it all in there and pay all the fees up front and pull an ID out of our ID manual. And so everything's there. The examining attorney can quickly and easily, well, maybe not quickly or easily, but more efficiently perhaps, examine your application and get it moving. So the question about international class, because some of you are like, Jason, I think you said there's no such thing as an international trademark and trademark rights are country-based. What does that mean? Well, we have agreed as the United States with other countries around the world that goods and services, right, those listings are going to be classified in 45 different international classes. And that means that, say, chemicals go in one, metal goods go in one, hand tools go in one, power tools in another, vehicles in another, clothing goes in another, sporting goods in another, and so on. Right? So think about them kind of as like categories or types of goods all go in one class, and your filing fee is going to be based upon the number of those classes that happen to appear in your application. So it's not based upon the number of goods and services, but the number of classes that appear based upon that number of goods and services. So when you're using the TEAS Plus version of the form, you have to use an ID that's in our ID manual, and the form is going to do that calculation for you. It's going to tell you what class your goods and services are in. It's going to tell you what your filing fee is going to be. So you don't have to like figure it out on your own. The form takes care of that for you. Just to be aware, there are reasons why your trademark could be refused. We've talked about these two, likelihood of confusion and descriptiveness, but it's also an issue if your trademark is geographically descriptive or your specimen doesn't support the goods and services that you've listed, or you're using your trademark in an ornamental manner. There's other reasons as well, primarily merely a surname, title of a single creative work, things like that. So there are many reasons why your trademark could be refused registration, which is another reason why we recommend you might want to work with an experienced trademark attorney. The other reason is because it's going to be up to you to enforce your trademark rights. We're not an enforcement agency. There's no trademark police. So if someone's infringing on your rights, you and your attorney might need to send them a cease and desist letter, or you might end up needing to sue them. The other thing too is that in order to keep your registration alive, you must file your documents, your post-registration documents with us. Because that's the great thing about a registration. Unlike a patent or a copyright, which will expire after a number of years, trademark rights can last forever, so long as you continue to use your trademark across state lines and you file your post-registration maintenance documents with us. Also, a quick warning, information in your file does become public. That's a requirement. That is in our rules. We have to make the information public, which for the most part is fine if somebody needs to contact you. Hey, I would like to license your trademark. Hey, great, right? But the problem is that there are companies out there that scrape our database and then they send you misleading solicitations. So just be aware, there are fraudsters out there, there are some scammers out there, and they're going to try and trick you into paying money for things that you do not need to pay money for. So if you check out the link that you see on your screen, you should get a copy of this deck, and so you can just click on the link from there. You'll see PDFs of a lot of these examples that we have seen over the years that people have sent us. So real quick knowledge check before we finish up. Are you guaranteed registration of your trademark? No. There are reasons why your trademark could be refused registration. And of course, easily enough, if your trademark registers, do you have to do anything to keep your registration alive? Yes. You must continue to use your trademark us. All right, so we're to the help phase, but I really want to answer your questions. So I'll just point out we have lots of great information available on our website. Check out these links. The bottom one there, our Trademark Basics Registration Toolkit, that's pretty brand new. It goes through a lot of the things that I've talked about today. You can download that quickly and easily and have it. It's a PDF. You can have it at your disposal. If you want more trademark content and you don't mind listening to me yammering on for 90 minutes, you can sign up for our Trademark Basics Bootcamp. It is totally free. It's on Tuesdays at 2 p.m. Eastern. It's an 8-week course. You can sign up for as many or as few as you want. We've gone through 3 weeks already, so we have 5 more left to go in this cycle before the next cycle begins at the beginning of October. So you can see the link there. We've had thousands of folks who have attended over the past year and a half and have really enjoyed it. So I'd encourage you to check it out if you're interested. And now I'm just going to also let you know, because I do want to get to your questions. Again, lots of information available on our website. If you want free and reduced price legal services, check out the Law School Clinic. You can see the link right there. If you want general information about trademarks, have general questions, you can contact our customer service folks at the Trademark Assistance Center. They're awesome. They do a great job of answering what questions they can, pointing you to resources. Be aware, however, they cannot provide legal advice. Same thing with me, cannot provide legal advice. And of course, as you can see, we can't help you enforce your rights, and we cannot recommend any specific private attorneys, but we do recommend you might want to think about working with an experienced trademark attorney. All right, so we have about 10 minutes for questions here, Jonathan. So did anything come in that I can answer?
Absolutely, and fantastic presentation, Jason. Really great information. So, but before we get into our audience questions, real quick, just had a couple questions of my own. First question. You mentioned a whole lot of reasons about or reasons why a trademark application might fail. So I guess my first question is, are there any tips that you can provide? How can one increase chances of successfully registering a trademark?
A lot of it is the reason that you're here today and that you're attending this webinar. It's education. It's helping you understand all the sort of issues that might surround a trademark. So, the big ones are likelihood of confusion and descriptiveness, but there are a lot of other reasons as well. Now, I'll show you this in case it can get pretty dorky pretty fast. I'll just let you know. But what I would, and the dorky thing would be to look in our trademark manual of examining procedure, which is what our examining attorneys use as their own guide and Bible. But what I would point out to you, a quick way to look at some of the common problems in applications is to check out our trademark basics page. As you can see on your screen, I'll show you how to navigate to it. You can navigate to it anywhere from USPTO.gov. Hover over trademarks up here in the first column on the left. Select Trademark Basics. It's going to bring you to this page right here. You'll probably recognize that little graphic. In the bottom right-hand corner, third column, Common Problems in Applications. Select that link right there. And this is a great way to learn about some of the things that you're going to want to be careful of in your application. As you can see, there's non-fixable mistakes. Those you really want to avoid. And then issues that you might be able to overcome. Descriptiveness, that can be overcome. Or specimens and things like that. So there are things you can do to overcome a refusal, but some stuff it's gonna be tough. Okay, so that's where I would begin anyway. But all the information that you find here on the Trademark Basics page is certainly here in the left nav of this page. Click on any of those things. There's all sorts of great information. Oh, and there's also a link here to the registration toolkit. So if that's of interest to you, I actually have it pulled up here already, just to give you a quick peek. Here's the toolkit. Sorry, it's sort of rendering itself there. But 6 kind of like easy steps depending on where you are in the process. You can quickly and easily learn where you are, and it links out to various resources. Great question. Thanks, Jonathan.
Really great. Thank you so much. And folks, I've included a link to that resource that Jason just pulled, the page that Jason just mentioned in our comment section. So be sure to look at that when you have the chance. So, Jason, since we have a good number of questions, we'll just move on to our audience questions right now.
Great.
So, first question. Um, so you mentioned at the beginning of the webinar that you can't necessarily trademark colors, but you can if it's. Correct me if I'm wrong, or if I'm wrong about this. You can attribute a color to a product if it,
Yeah, if it
yeah,
indicates source,
if it indicates
yeah,
source. Yeah,
you can register a color as a trademark if it indicates source. But it's going to be
gotcha,
kind of an uphill battle to get there, but you can do it. Yeah.
gotcha. So the question from our audience member David asks, "What about background patterns?" And
Patterns can sometimes, yes. If you think about like a Louis Vuitton bag or Burberry plaid, yes, it's possible for background patterns, so long as they indicate source and and you're able to prove that consumers, when they see it, they automatically think of you. Yes, it is possible to register those sorts of things.
Gotcha. Fantastic. Thank you. Thanks for the question, David. So our next question from Syed. Can you trademark logo and name together as a bundle, or would you have to send in separate applications for both of them?
Great question. You could do either one. But here's what it really boils down to. How do you use your trademark? Do you always use it together as a logo and the brand name? Or do sometimes you use the logo alone and sometimes use the brand name alone? Now, I can't answer that for you. It's going to be up to you to make that business decision. But if you always use them together, sure, put them together, now you can't combine a logo and a standard character mark. So your wording is going to be in whatever font it is that you want to register it in. Okay. But if you always use those things together, cool. That's one application, probably in black and white, not legal advice. But you could submit that and you'd be fine with your $250. But if sometimes you use the logo alone, sometimes you use the brand name alone, you might want to think about two applications. One for the logo, probably in black and white, up to you, and then one for the brand name in standard character format to give you flexibility. Because think about, you have to prove to us how you are actually using your trademark. So if you always use it together, you're going to submit what's called a specimen that shows how you're using them together. And if you use them separately, it's fine if your specimen for the logo also has the brand name on there. It's probably going to be okay. I can't guarantee it. It depends on every situation. It's fact specific. But for the most part, it's probably going to be fine. And if for your specimen for your standard character mark, the version of your wording, Jason, right? If that has the logo around it on the specimen, yeah, that's going to be okay too, because we're really just worried about the wording. Does the wording appear there and function as a trademark? So it's going to be up to you in your specific situation. Do you use them separately? Because if you do, you might want to register them separately, even though on occasion you mix and match and use them together and maybe put one above or off the side or whatever it happens to be. That oftentimes business owners do that because it gives them great flexibility over the life of those trademarks.
Really great insight. Thank you. And I hope that answered your question, Syed. So this next question. Sorry, let me just remove that one right there. So this next question, we've got a couple similar questions actually about this. So our audience member, sorry, let me pull it up. Irv asks, "Can an internet domain be trademarked?" Let's go with that first
Mhm.
question first.
Yeah.
Can it? Can
Yeah,
okay.
so you can register a domain name as a trademark, so long as you were using it as a trademark, right? So much like a business name, it really depends on how you use it. So if you think back to the early days of the internet and of Amazon, well, everybody was registering blah, blah, blah.com, all right? Those were all registered trademarks. They're also URLs. And that's totally fine. You can do that so long as something is functioning as a trademark and you can show, hey, USPTO, in addition to it functioning as a web address, it's also functioning as a trademark. You would just need in your specimen to show us not the name appearing in the little address bar at the top, but in on your product or on your web page somewhere,
Mm,
that full URL that you're using, Amazon.com, like appearing as an actual trademark. Great question.
gotcha. Thank you. And so the second part to this question, can a trademark be tokenized? For instance, can it be made into an NFT?
You know, that's a great question. It is certainly an emerging field.
Mhm.
Okay. We are working our way through how all of that works and how things work with NFTs and virtual goods, digital goods. So if so, I don't know if I can answer your specific question about tokenizing a domain name, but I can tell you that lots of folks have started applying to register their brand names, essentially for use in the metaverse, for use as a brand name for an NFT, or for some, downloadable software, sort of thing that can be used in a metaverse. So it is possible to register something for those sort of digital goods, which would exist in the metaverse or somehow be blockchain related. So I'm sorry I can't give you a specific answer about whether a domain name can be tokenized and registered, but I can tell you that there are plenty of folks who are planning to register trademarks for those sorts of things, for digital and virtual goods.
Gotcha. Thanks for the question, Irv, and hope that answered your question. So, Jason, since we are at the hour, just wanted to ask, because we do have quite a few questions. Would you happen to have about 5 more minutes to stay after so we can
Sure
answer
thing.
as
Hit
many
me.
questions?
We'll get as
Great,
many as we
thank you.
can. Go for it.
Great, thank you. And to our audience members, I just wanted to let you know that if we can't get to your questions, I have linked the USPTO resources and trademarks pages, and I'll do so again at the end, just so you can have access to those. But thanks for the really great questions. This next question from our audience member Lee, could you explain the differences between trademarks versus service marks,
Great
if there is
question.
one?
Yeah, there isn't really a whole lot of a difference. The word trademark encompasses both trademarks and service marks. Sometimes you'll see people who provide a service. I don't know. Think about McDonald's applying a restaurant service, right? They have a restaurant service. That technically, I guess, would be a service mark. And so before registration, maybe they used an SM, but there isn't really much of one. It's because you can use the word trademark to accomplish both. You can even use the word mark. I probably said that multiple times throughout the day today, and that's totally fine. So great question. Not a whole lot of difference. Trademark indicates the source of goods. Service mark indicates the source of services.
Gotcha. And I guess this kind of goes into the next question. Our audience member Dominic asks, or so our, it was a two-part comment. So Dominic wants to trademark a logo for his granddaughter's soccer team. And I think the question he's asking is, can he trademark that logo considering her service, or it's for soccer playing and not for a t-shirt sale, or what the logo is
Ah,
being sold for. So, or
yeah, great
for to be
question.
monetized. So can that logo be trademarked?
It depends on what you were trying, the underlying good or service that you were trying to register it for.
Got
So if it is a service, what is the service being provided? Is it soccer playing services? Well, that's not really, unless your granddaughter is like providing professional soccer services for others, because services always have to be provided for others. It is an activity that you perform for others, whether for pay or for free. So it's not something that you do naturally as part of your business or whatever. It's something that you do for others. Okay, so your granddaughter is probably not, necessarily providing soccer playing as a service. Uh, you know, we'd have to look it up in the ID manual, but it could be there are services that the entertainment services, namely providing uh, soccer games or something like if you were the one who is setting up the games, or running the league, or something like that, then that could be perhaps, I don't know. Again, I have to be very careful because I'm not allowed to give legal advice.
Right.
But it something that would go on a t-shirt or a jersey or a pair of shorts or socks or a hat or a headband or whatever. Those sorts of things, typically, if it's just appearing on the goods themselves, that'll be refused registration as being ornamental because it's not indicating source, it's just being used ornamentally on the uniform or the t-shirt or whatever. However, if that same logo is actually being used as a brand for a particular type of good, like a shirt. So maybe it appears on a hang tag, or maybe the logo appears on a label, or it's on the packaging for the goods, or it appears in what's known as a traditional trademark location on clothing, which is the left breast pocket area, a sort of small, neat, and discreet logo. Think about your Polo Ralph Lauren, or Izod, or whatever whatever the case is. The little guys that are right there. Brooks Brothers, I think, has like a pig or something like that. Right. So that sort of thing that can sometimes function in your specimen to show, yes, it is being used as a trademark in a trademark related way. You just have to be careful that it being emblazoned across the front or all over the place. Those are going to get refused as being ornamental. So my only other caveat there would be, depending on what the logo is, just be very aware. Oftentimes logos, especially soccer logos and things like that, sometimes look pretty similar to other people's. Okay, and sometimes for teams with younger folks on them, you're like, oh, we want ours to look kind of like, I don't know, Manchester United or whatever, And so sometimes people take elements, right, from other people's trademarks and incorporate them into their own. So it's possible, maybe, but you just want to be very, very careful about what you're doing so you don't sort of run afoul of other people's rights.
Gotcha. Thank you. And Dominic, hope that helped. If you need more information on that, again, would definitely recommend going to the USPTO website for all your answers. So thank you, Jason. So
Yeah, let me show
we'll
one more thing. As
yeah,
you go ahead and ask me the question. I'm going to go ahead and pull this up right now. As you can see on the screen, there's a link here on the left-hand side, hiring a U.S. licensed attorney. If you're in a situation where you're like, ooh, I really want to protect the logo for my granddaughter's soccer team or whatever, you might want to talk to an attorney. They can be expensive, as I noted. So I'm going to scroll down here to the bottom, and you can see this section here, free or reduced fee legal services. So one is the law school clinic that I mentioned. You can also check out resources on the American Bar Association site and also the International Trademark Association's Pro Bono Clearinghouse. So if you happen to meet certain income eligibility standards, you might be able to avail yourself of these free or reduced price legal services.
great. Thank you. And folks, I've also included the link in the comment section. This question, Jason, is a very simple one. Let me just pull it up. Habib asks, how long does it take from filing to grant a registration?
Great question. There is no specific answer that I can give you because there's no guarantee that trademarks will register. So it could be that they're refused and they never make it to registration. I think the question you're probably mostly asking is, come on, Jason, on average, how long does it take? Well, we typically say it takes 12 to 18 months for a grant of a registration. It's a little bit longer now. 18 months is probably the early end, and I can explain why that is. But that's about the average. The quickest that I probably ever saw when I was examining was about 7, 8, maybe 9 months, somewhere along those lines. And the reason is there's a lot of process that happens in there. For part of the time, your application is sitting and waiting because there are lots of people in front of you. And then the examining attorney has to examine it. And then there's back and forth, perhaps with you. And that takes some time, especially because you currently anyway, as of July of 2022, you have up to 6 months to respond. So sometimes that makes things slower because sometimes people don't respond right away, right? They procrastinate a little perhaps and wait the full 6 months. And then there's back and forth again. And so that can extend the time. Opposition period is 30 days, right? So you have that time there built in. So it's typically on average 12 to 18 months. The reason that's longer now is we had a huge surge in filings during the pandemic. We used to get, we were getting about 600 to 650,000 application classes a year. And then in the summer-ish of 2020, the number of filings went through the roof and we got closer to 900,000. I think we were bumping close to 1 million at one point, right? So that is a lot of work. Now we're obviously taking steps to try and work through the backlog, hiring more people, taking on, other things that we're doing, but it's still going to take time because it takes time to go through and give quality examination to every single application. So there's a lot of work to be done. And so that means what typically used to take about 3 months before an examining attorney would touch it for the first time is now 7, sometimes bumping up to 8 months. So that's going to push back the amount of time that it takes to get you to registration.
Gotcha. Thank you. And Jason, going back to Dominic's question before about the soccer logo question, I do apologize to Dominic. I didn't read the full question out loud. Or sorry, I didn't read the full question, which I probably should have done. So Dominic did clarify that she is playing for as a service for the LA Angels for LA Angel City. So I hope that
Okay.
that helps. So Dominic, I do apologize for that.
Yeah.
But
So yeah, so people, celebrities, athletic folk out there, if you are providing a service for others, right, that is something that is being provided, folks will sometimes register their own names, right? So think about, Beyonce, right, is a registered trademark probably for entertainment services, namely live performances by a musical artist. Her name is probably also registered for, various, downloadable musical recordings, things like that, probably for some clothing, things like that. So yes, it's absolutely possible to register someone's name. You could register your granddaughter would potentially register her name, right, as the trademark because she provides very particular services. So it would just be a question of how are those services worded, and you just have to do a little fooling around in the ID manual in order to find something that accurately reflects what it is that your granddaughter is doing. Congratulations to her, by the way. That's awesome.
yeah, absolutely. And I hope that helps, Dominic. I do apologize again for trying to paraphrase that question. We are running out of time, but hope that helps. So, Jason, I think we are going to cut it off there. Unfortunately, we are out of time. I know we could go on and about this for a long time. Um, but folks, if we were not able to get to your question today, make sure to check out the USPTO website, where you can find plenty of information on all your intellectual property needs. Jason, we really appreciate you joining us today and providing your audience your insight into the benefits of trademarks and what businesses should know about them.
You're welcome. Thanks so much for the invitation. I appreciate it.
Absolutely. And thank you to everyone for attending today's live stream webinar and your great questions. As mentioned at the beginning of the webinar, we will be sending a short survey to all registrants after this event. Would love your feedback. Our fifth and final webinar in the intellectual property series on patent searching will be on Wednesday, August 17th at 2 p.m. Eastern. The registration link has been provided below and in the comments section. Can't wait to have you all with us again. Please don't forget to share, like, and subscribe to our channels on social media and check back daily for future live stream updates. Have a great day, everyone.